Okay, we'll move now on to the second area on our structured agenda. That's the takutai moana customary interests. Do we have an opening question from any member?
Sure.
Go, Steve. Yeah.
What is your response to the Supreme Court?
Well, what's else? I mean, our starting position on all of this is, a determination to acknowledge treaty settlements and commitments made in the treaty and including discussions around customary rights, while never losing sight of the basic expectations of New Zealanders to live in a modern democratic setting where all New Zealanders will sort of have equality before the law and, broadly speaking, an equal say in what happens in their environment. So we're very conscious that all New Zealanders have an interest in what happens in the coastal area, and the takutai moana regime, insofar as that could lead to the granting of customary marine title, materially affects that. It gives the ability of somebody, a group that has customary marine title, to make decisions in relation to resource management on a bunch of areas. So our view is that Parliament, when it passed the legislation, always had in mind a very high threshold for that, which had two legs, one based on tikanga and the second one based on continuous possession since 1840 and occupation of possession. So the Court of Appeal materially reduced that threshold. We introduced legislation to overturn that. Then before that legislation was concluded, the Supreme Court came in, and the government is still considering its options in response to that. And I can't give you a government decision on that, but we're actively considering that at the moment.
Do you think it's fair, the accusation that your introduction of the legislation before the Supreme Court finding was a knee-jerk reaction, and in fact the many wise commentators and observers suggested that it would have been better to tie-ho and wait and see what the Supreme Court says, and in fact the Supreme Court found in favour of the Attorney General's appeal?
No, I wouldn't say it was knee-jerk. It was interesting that the Supreme Court came to a conclusion so swiftly on that element. But no, we felt that we need to be clear about that. And so we have had three courts with three different interpretations of the legislation. And so obviously we're working our way through our response, which could range from leaving it as it is following the Supreme Court, or carrying on with the legislation that's been introduced in some amended form, recognising the Supreme Court decisions. And that's something that the government's working through at the moment.
What are the odds that you'll leave it as it is?
I won't put any odds on it.
Jenny?
Thank you. Interested to know why you chose to ignore the Waitangi Tribunal suggestion that the government should halt all efforts to amend takutai moana. And also...
Should halt all what, sorry?
Well, there was a Waitangi Tribunal recommendation that the government should halt all efforts to amend takutai moana. Do you agree with the tribunal that the current actions by the government breach the treaty?
Well, first, I disagree with your characterisation to say that we ignored the Waitangi Tribunal. We didn't ignore the Waitangi Tribunal.
What did you do then?
We read their report and considered it, and we didn't agree with it. That's a very different thing to ignoring it. And ultimately, the point I was making at the start is that what we're trying to balance is a regime that provides the opportunity for groups to make a claim based on customary title to the foreshore area against the very real interest that all New Zealanders have in what happens on their coastlines and in our seas. So we're we're a nation and a culture that obviously loves the coastline and is very interacting with it and live alongside it. They have, and so everybody's got an interest. And so what the legislation was trying to sort of pitch that at a particular level with a high threshold before customary marine title is granted. So it's very much within the preserve of government to have legislation in that space.
Have you got a time frame when the government's going to respond to the current situation?
In due course.
This year?
Well, look, I'm not going to put a time frame on it, but we're actively turning our mind to it, and we're conscious of the fact that we do want to resolve these issues sooner rather than later. Broadly speaking, we are concerned about the whole framework that's developed. I am worried that we could see that the way that it's currently set up, we could be having court cases for many, many years ahead on these issues. And we could still be debating it in 2040. And so I'm worried about that. And so we're actively turning our mind to how we can come up with a more efficient process so that people can get on with things.
Steve.
Yeah, just taking it a bit more broadly, Minister, is it reasonable to suggest that whakatā moana, the marine coastal environment in which diverse iwi have interest, and often those interests overlap?
Yes.
But of course, we're talking about essentially literally a fluid landscape where multiple interests can move across that space.
Yep.
And that in fact, recognising the sovereignty that an iwi retains to the whakatā moana does not threaten the access and use by other parties. And so the sense, I think, the feedback that we get from iwi is the sense of this removal of a recognition of sovereignty, or for iwi to have to go to great lengths and great expense to fight for recognition of sovereignty, which seems self-evident because, of course, iwi Māori have had use of that whakatā moana for centuries and centuries and centuries. Why is it that the Crown needs to clamp down and essentially have the effect of confiscating or extinguishing that sovereignty? Because it's not a barrier to use of the marine coastal environment by other interests.
Well, I mean, I think a lot of people just trying to go about their business would have a different view around who is sovereign. I mean, that's a broader discussion, which we've already sort of talked about. But ultimately, the legislation that's drawn out would have the holders of customary marine title do have very significant powers in relation to resource consents and so forth. So people wanting to build a jetty, people involved in aquaculture, people going about a whole range of processes would have to have the permission of a local group, which is a very significant change to where we are at the moment, and not a material issue. And so our view has always been along that in order to do that, which is a significant deviation from the basic principle that everybody has an interest in what goes on in our foreshore and seabed. That is why there was a high threshold in the legislation.